Good afternoon, Mr. Dimmick.
Good afternoon, Your Honor. May it please the court, my name is Radford Dimmick. I'm an attorney here in Nashville, and I represent Jeremy Faulkner, in this case out of the Chancery Court in Giles County. This matter involves...
How much time do you want to reserve any rebuttal?
I apologize, Your Honor. I'd like to reserve 3 minutes.
3 minutes, yes, sir.
This matter involves a limited issue of standing regarding a will contest. For purposes of making sure that I'm clear in referencing the parties, I tend to reference their first names because everybody in this matter's last name is Faulkner.
Yep.
The decedent is Floyd Edward Faulkner. I represent Jeremy. And the personal representative is Brenda. Brenda is represented by my colleague and friend, Mr. Hillhouse. And
your client is a nephew but would not inherit intestate.
That is correct. He would not inherit under the laws of intestacy, and the only way that he could establish standing in this matter to contest the wills would be to show that he was a beneficiary of prior wills. We would submit to the court that he has done so. In this matter,
he presented a single page of a will.
Of one will,
right,
and the complete wills of 3 prior wills to that. There were several wills that he was a beneficiary of. There was a single page, it's admittedly not a complete will, that it was prepared and executed in November of 2019. I don't pretend that that's a complete will, but it's very evident that there are at least 3 prior wills and 1 partial prior will that names Jeremy as a beneficiary. All of that information was presented to the court. The Chancery Court of Giles County found, and they relied upon the case of the estate of West, and stated that essentially because Jeremy did not overcome the presumption that these prior wills had been revoked, that he couldn't sustain his claim of standing to contest the will of the
And so does the estate of West stand for the proposition that a will contestant has to present the original wills in order to establish standing if they can't take intestate?
It would seem so, but the latter cases of the estate of Brock and the estate of Sieber seem to indicate that you can...
Well, doesn't the estate of Brock, though, really stand for the proposition that if an earlier will, there's validity to an earlier will? I mean, it seemed like to me what the Supreme Court was trying to do there was to clean up what had been a mess before. So I'm not really sure estate of Brock really helps you any, does it?
I think it does, because it stands for the proposition that if there are prior wills, and in the estate of Brock, the wills that were presented were copies. And copies alone don't necessarily meet muster. And the whole reason why this is tied up by the estate of Sieber, the estate of Sieber goes forward and takes Brock a step further and says essentially that if you have to go and litigate the validity of each and every copy of the will, of every copy of every will that is presented, you're defeating the whole purpose for the will contest to begin with. All we're asking for today is the entry into the doorway of the will contest, and we're trying to establish standing for Jeremy in this case. So in order to establish standing for Jeremy, I would submit all we have to do is show the existence of at least a copy of a will. Now in this case, the reason why we know about these copies is because 3 of them were in, 4 of them were in the possession of Brenda. Well, Brenda has these wills, so Jeremy can't very well establish possession of the original wills because they're in the care and custody of his adversary.
But you're saying that your client did present copies of these wills to the court?
That's correct, and it's in the record that he did so. These copies, and they were copies based upon a prior lawsuit that had been filed by Brenda in which she openly questioned the validity of all 4 wills, including the will that was admitted to probate in this case. So that case was subsequently non-suited before she then tried to present the current will, which is the April 29, 2020 will. All that was presented by Jeremy in the hearing for standing were copies, just as in Brock and just as in Sieber. And the reason why we think that standing is now established under the mandate of Brock and Sieber, Brock, I believe, clearly states that if there are prior wills that name the contestants or where the contestant can benefit, then those wills have to be brought up into the will contest. And Sieber takes it further. Sieber distinguishes the West case because the West case only involved a will that was unsigned, and it even distinguished other cases, the Warmoth case, in which there wasn't even a draft of a will. But specifically, the Sieber case stated that requiring contestants to prove facts of the validity of these copies of wills at the juncture of standing would in essence be requiring the contestants to prove the very merits of the will contest itself. And the reason why the Sieber court took notice of that and the Brock court took notice of that is because they wanted to avoid the potential of any fraud that may have, in this case, be borne by or accomplished by Brenda. Now, I'm not in a position here that I can level facts that Brenda has committed fraud, but the whole reason why the courts have allowed for copies of wills, to allow for standing to open the door to a will contest, is so that it can be litigated in the will contest. The only thing we're asking for today, and the Brock case is very clear on this, we may get our you-know-what's handed to us in the will contest. We may not prevail on the will contest. We have a high burden in the will contest, but that's not what today's about. Today is about opening the door for the will contest and establishing standing for Jeremy to get there.
Counsel, is there a difference between a lost will case and a case in which you're purporting that the other party or another party has the will in their possession?
Is there a difference?
How should we look at those differently in terms of standing and what you have to show? And you're not arguing that the will has been lost here. You're arguing that it instead is somebody else has the will.
I'll take it further. I don't even know I'm there yet, because what I have is I have a prior lawsuit where I know that at least copies were in the control of Brenda. I believe that they are originals. We haven't been able to get to the will contest because, for reasons that the Chancery Court of Giles County relied on by relying on the estate of West, which I would submit the facts of that case are inapplicable to this case. By relying on that case, we don't even get to that choice yet. So what my adversary is going to say is, because there's a presumptively invalid will, because all we have is a copy, and because this was the holding of the Chancery Court in Giles County, because there is a subsequent will that has been admitted to probate, which we are trying to contest, that says all prior wills were revoked. Well, we're trying to contest those words in the will. And one of the clauses in the will is, I revoke all prior wills. So for that reason, it doesn't really matter if this current will states that it revokes other wills if it's subject to being contested, because if it is eliminated, for lack of a better term, or set aside because it's found to be an invalid will, then that clause revoking the prior wills is also revoked. So we don't get to that. I go around to Knoxville to get back to Memphis and tell you we don't get to that part of it yet, because we haven't been allowed to explore that yet. But we do know that with our copies of at least 3 prior wills, a part of another will, all of them were signed by the decedent, all of them named Jeremy as beneficiaries. So for all those reasons, we think that that would open the door to it.
Do you have a motion to consider post-judgment facts pending in this case?
It was denied.
Okay, all right.
And it was denied probably because I think I did it the wrong way, just to be real candid.
Okay.
But in light of that, we think we have set forth facts. There is adequate information in the record that shows that there are multiple prior wills in this matter for which Jeremy would benefit. The reasoning employed by the Chancery Court of Giles County, I would suggest, is reliant upon a case that does not apply in this matter, that case being the estate of West case. For the reasoning for the Brock case, the estate of Brock case, and the estate of Seaberg case that unfortunately only came under my radar after I'd filed my brief in this matter, I think very plainly allows for the finding that Jeremy has standing to go forward on his will contest. And at that point, the issues regarding the validity of these prior documents can be determined. And I'll yield the remaining part of my time unless there are any
All right,
others.
we'll hear from you on rebuttal, Mr. Dimick. Thank you. Good afternoon.
Good afternoon. Randy Hillhouse from Lawrence County Bar. And the way I look at this case is definitely different than the way the appellate does. The way I look at this case is the appellant had, I believe it's 4 different opportunities to produce a will which did 3 things. One, was properly executed. Obviously, the one page he did with his amended does not show that. There was no testimony about any of the prior wills. At least from our position, they should have attempted to provide the judge with proof that they had a prior will that was properly executed. That gave, it's a grandson, I think, not a nephew.
Sorry.
Not that I think that matters, because the father was still alive, so he wouldn't inherit. But they gave the grandson something. It just happened in my notes, so I wouldn't even say it. And number 3, that the will was not revoked. Judge Stockwell's principal opinion appeared, at least from the appellee's side, to be that they didn't show any of those. There was absolutely no testimony about the wills, quote, prior wills, prior documents not being revoked. I don't think the law requires...
Were the documents or copies of the wills filed with the court?
Along with his brief, I believe it is. They were never mentioned. There is no transcript, so there's no testimony. And we submit that that's one of the places where they came up short, that they should have brought in proof that whichever will they wanted to rely upon was properly executed, that it gave the grandson something, and that it hadn't been revoked. Because there is a pretty good presumption for us that if you cannot find an original will, it's presumed to have been revoked. And in this case...
But in this case, you've got a latter will that expressly revokes prior wills. Is
Well,
that
you
correct?
have that, which
Is that-
might would revoke it. I think each of the 4 copies that they had revoked prior ones. So it wasn't just our will and the last will that revoked it. It was all the others revoked too.
So your position is there's 3, at least 3, well, 4, I guess, including the one that was submitted to prorate, that are in the record, but the problem is that 3 of them, the earlier 3, are appended to a brief and not submitted with a declaration or affidavit, and that's you're saying that's the reason why the court could probably ignore those. You needed something more than that.
I think you do need more than that. This record is just not sufficient, we submit, to give them standing.
Are you conceding the point that a copy would have been enough had there been a proper declaration or affidavit or something to show that this was a valid will, or are you saying that the original would have? had to be submitted as well?
It's a close question, but I think the answer is.
Okay, if you're not, well, I don't want to force you into concession.
No,
You're
it's
not
all
willing to
right.
that, yeah.
I thought that was y'all's job, was to force me to concede whatever. If that will is a copy, I think they have to produce at least an iota of proof that it was not revoked
Yeah, I see.
by the testator.
Okay, yeah. I
So
follow.
I'm close to agreeing with you, just not quite, just a little bit off. And if you look in the record, you have Mr. Faulkner, who died in 2020. This probate was not filed for over a year. A year later, we file. A year later, they object. When they file their motion wanting standing, they did not attach a copy of any will, even the front page of any will. They said, well, we're the grandson, we're an heir. Well, we filed almost immediately saying, no, you are not an heir. If Mr. Faulkner died intestate, you get 0 because your father gets it. And the will did mention his father, mentioned the 4 children he had, his father being 1. After we filed our opposition to their motion for standing, they then did an amended. That was when they added the 1 page, which is clearly not sufficient because it's not dated. You don't know when it was done. You don't know who the witnesses were. So they had that opportunity to present something. Then we had a hearing. At the hearing, they presented no testimony on it. But Judge Sockwell said, well, I don't really find that you got standing now, but I'll give you another chance. And he gave them another chance. And did they produce any testimony about a new will then, or an old will, original will, any will? They did not.
So only your client filed a brief in that request, correct?
They filed a brief, but they didn't put on any proof.
I see.
And maybe I'm wrong, maybe Your Honor will be the one to determine, or y'all three will, whether you're required to put on proof. But to me, they should have put on proof that here is a will that is, at least on its face, properly executed, that on its face gives a grandson something which gives him standing, and something showing it had not been revoked. Now, they rely upon saying that my client had these original wills. All of the testimony, and they did her deposition, which once again is not in the record, so I'm going out of the record. But they should have to do some of that, some proof, put on a prima facie case. And if they put on a prima facie case, then I think a couple of these cases will say you would submit both of them to the jury, and the jury would decide. Of course, if the jury decides that ours is properly executed and that Mr. Faulkner was competent, it solves the issue because our will specifically revokes theirs. The only way their will has a shot is if we're not competent to revoke their will. That's everything I've got to say unless y'all have some questions.
Hearing none, thank you, Mr. Hillhouse.
All right.
Mr. Dimick?
That's not quite how it went. There were 2 hearings regarding standing, and the second one was an invitation from the Chancellor of Giles County for all parties to provide any information regarding prior wills, and that was done. The prior wills were attached as exhibits to a lawsuit that had been previously filed by Brenda herself. So they were under oath at one point in a prior lawsuit signed by Brenda herself, and they were presented to the court in this case.
What kind of lawsuit was that?
It was a lawsuit to open an estate, and it was not filed by Mr. Hillhouse. It was a lawsuit to determine the validity of which of these 4 wills that we suggest show that Jeremy himself had standing to contest the April of 2020.
A lawsuit to establish the validity of a will is a petition to probate a will. Isn't that what?
In essence, yes, Your Honor. And that,
And so was a certified copy of that lawsuit filed so that it was self-authenticating and the court could take that as evidence? I mean, don't you have to do something more than just file something? It seems like to me that under our statutes, there's a factual determination that gets made here, and that requires some proof or evidence, and I think it could be documentary form as long as it's submitted with a necessary declaration or affidavit. But then there have to be more than just filing it with the court, attaching it to a pleading?
well, in hindsight, it probably should have been a certified copy, but it was also under oath signed by Brenda. And there was no objection to it in the underlying court that it being admitted. It was denied, and the reasoning presented by the court as to its denial was not that it was not authentic, but rather that it had been revoked by this very will that we are trying to contest. And for the reasoning of Brock and Sieber, I go back to the notion that because these wills are there, they were filed, they were signed, and they were admitted to under oath by Brenda in a prior proceeding. For the reasoning of Brock and Sieber, whether or not any of those wills are valid, including the most recent will that purportedly revokes, and that was the reasoning used by the chancellor in Giles County, if indeed the current will is valid, if indeed the prior current will or the second to the next will is valid, or so forth, all that has to be determined in the will contest according to the mandate of this court in Sieber and the estate of Brock. So it's been brought to the attention of the court of the existence of these wills. These wills were signed, were presented under oath by Brenda in a prior proceeding. So I think that any prejudice or that would have befallen them is non-existent. I'm out of time.
All right, thank you, Mr. Dimick and Mr. Hillhouse. We'll take this matter under advisement.